Welcome to tonight's webinar on interpreting in family court. Our presenter is Carla Mathers. My name is Carrie White, and I am the Marie Center Coordinator, and I have a few things I need to talk with you before we begin. Captioning and interpreters are provided. The streaming window opens automatically. There is a tab for the audio and video on the far right. Click on the bottom corner and a menu will drop down. Click Detach Panel. Then you can resize the video box. To open the captioning, click on the captioning icon on the toolbar. Windows can be closed or sized to create your personal viewing environment. The chat window can be made bigger by pulling it out. Click on the icon box in the upper right corner of the chat box to access the menu, and then make the chat font bigger. If you have technical issues, use the chat function and a member of the clearinghouse staff will aid you. Questions for the presenter will be in the chat function. Please write down your questions and then wait for Carla to ask for the questions, then type them into the chat box. At the end of the webinar, when you close out, a survey will populate. Please fill out the survey about your experience, and also at that time your CE information will be gathered. I will talk more about CEUs at the end, and for right now I'd like to turn it over to Carla.
Thanks so much, and welcome back everyone. This is the third in our series of legal interpreting webinars entitled Interpreting in Family Court. And so first I'd like to thank Carrie and the Marie Center and our techie who's busy hopefully helping all of you who are still struggling, Jeffy Zhu, and the Center Director, Anna Winnemarathu, and Lilani Johnson for all their support in all 5 of these seminars. If this is the first one for you, then this will not be repetitive. I need to apologize to my deaf colleagues because the tradition in court interpreting is to present in our shared language, a language we all have access to. But due to the technology currently available, the safest way to make sure that all of the content is accessible is to have interpreters and captioning. There's only 356 of you registered. I don't know if everyone will actually come, but I have to say that's a pretty amazing number who are taking advantage of this resource. Another just side note is if you cannot get in or are having difficulty getting in, just Google NCRTM, the National Clearinghouse of Rehabilitation Training Materials. A number of people have emailed me, and I'm not checking emails for the next 90 minutes. Other than criminal and traffic court, family law is where we are most of the time. And not only are we there, it's very high stakes interpreting. So I'm really thrilled that so many people have decided to take advantage of the training, and it indicates that there's a huge need for it. So we're going to do our best. It might sound sometimes a little bit like a law school class, and for the lawyers on the list, you probably want to tune out. But it's because there's a lot of definitions that we'll go through, procedures and terminology and vocabulary that are specific, sometimes just to the states that I am licensed to practice law in. But the concepts generally will apply wherever you are. You just may use different terminology for them. So we'll go through these separate domains. We'll talk about some of the major issues that you will face in a family law matter, including separation and divorce, property, which typically means money, but there's different kinds of property issues, We'll talk about the most common child custody and visitation issues and explain what those are, including child support. We'll briefly touch on some domestic violence matters that are heard in family court. And then close out, and we're not going to go into that much further because the next session will be devoted entirely to domestic violence and interpreting in those settings. And then we'll touch on the abuse and the neglect systems. We'll also, throughout, we'll talk about the interpreting issues that come up and the challenges that we face and the different aspects of interpreting in these types of matters and the implications. So, as an overview, I mean, generally the roles interpreting in family law are the same as for any other setting, although because preparation for a domestic trial is extensive, there may be a larger role for the law office interpreter and to interpret that preparation as well as then to be present to monitor the court interpreters. Family law interpreting happens in a variety of settings, including in actual court. Much of it, as I mentioned, happens in the law office. You might interpret a deposition. You might interpret a mediation as a part of a family law matter. And you might interpret a supervised visitation for deaf parents or deaf children and their parents to visit each other. There's a great deal of sight translation in addition to regular, consecutive, and simultaneous interpreting. Sight translation is an important part of our job. And the conflicts that exist for legal interpreters in family law settings can be extensive. Because there's so much preparation involved in the typical litigated matter anyway, the interpreter who works any of that then cannot work in the proceedings except as a table interpreter. So if you have multiple deaf parties and you have potentially children or deaf children who have their own attorneys, then it's very quick that you can get conflicted out if you're not really careful about allocating your interpreter resources so that you keep those lines clean and that you save a couple of interpreters at least for the court work who don't have any taint from any of the pretrial preparation. And I know that that's difficult to do in areas where there isn't where there isn't a whole lot of interpreters or a lot of interpreters, which is nowhere. So just to keep in mind when you're staffing those cases, it's very easy to conflict it out. There are a lot of good resources that we'll mention as we go through, but there are resources for learning family law, and you need to look at your state court interpreting site because they will have information for pro se litigants, and that's very good information for interpreters to use because essentially it's telling people who are not represented by counsel what they need to do in order to get a divorce or to file a motion for custody. So it's a good place for you to go, as well as you can also try the American Bar Association has a family law section, and I tried to use a good deal of their information because the problem with family law is that for the most part it's governed by state law, and there's 50 different states, so there's 50 different statutory schemes that set up how your individual state is going to handle family law matters. And I'm only licensed in 2 of those states. So I set a huge caveat out ahead of time that this whole presentation is not to be considered legal advice, first of all. And I'll try to point out when I'm talking specifically about Maryland and the District of Columbia where I am licensed. But in general, you really need to look at your specific state, their court website, or even just a general domestic law search on Google. You'll get a good deal of information. So we're going to start with some of the major issues that you can anticipate that you'll be faced with in interpreting in family law matters. And as we've done all along, I'll stop at times and take questions after we get through a specific chunk of information. So, some of this is going to sound like I said, a dictionary class. I'm going to do a lot of defining of terms, because regardless of what it may be called in your state, the concepts are still probably going to be present. So in order to file any kind of a divorce, you have to have grounds, and grounds must be understood. Grounds are not something you sleep on when you can. Grounds are the legal reason that the legislature permits you to file or to seek a divorce from the court. You can't just get a divorce in most places because you want one. You have to fit into one of these specific areas or grounds. And when you have grounds and you qualify for all of the other portions of your particular state statute, then you have standing to file this divorce. So grounds are just a legal reason. Sometimes those grounds involve being separated a period of time before the court will grant you a divorce. And generally, in most places, there's some provision for this separation in a period of time. But if you're separated, you may have these interim issues that you can't agree upon among the parties. And so you ask the court to help you with this temporary support, temporary items. So, for example, you physically separate, and then one party goes to the court and asks for temporary child support. That is called a limited divorce. During that period of separation, and you've gone to the court and you've asked the court to decide certain interim issues, is what we in Maryland at least call an interim, a limited divorce. Then you get what assistance you need from the court, and then when your period of time you've been separated long enough under your statute to get a final divorce, then you come back in, and that's when you get your final divorce. So that period of time is called pendente lite. It's a Latin term, and it just means pending, essentially, while we're waiting for your grounds to ripen, which is what it's called when you have qualified by being separated long enough to get a divorce. Then your grounds have ripened, and you are qualified then to get a full divorce. So during that interim time, you might hear or interpret motions for temporary maintenance, and that's a term that means temporary financial support. It might be for child support, it might be for spousal support, but it's a temporary until the grounds have ripened. One might be asking for child support, for attorney fees, costs, expert witness fees, custody, visitation, enforcement or modification of prior temporary orders, or requests for exclusive possession. An exclusive possession relates to the home or the family apartment or condo or wherever you live. One person's going in and asking the court to give them the right to live there. So those are all the kinds of pendente lite motions you might hear. So in Maryland, we have, by statute, we've got grounds for this limited divorce. And those include, we have 4. And it's probably fairly general that these or more will be in your states as well. You can ask for a grounds, you can ask for a limited divorce based on cruelty of treatment, excessively vicious conduct, which are 2 relatively new grounds that were added when the emphasis on domestic violence became so prevalent. Another ground in Maryland is desertion and voluntary separation. If certain elements are proven, you have to prove that the parties lived separate and apart without cohabitation, and that there's no reasonable expectation of reconciliation. That's what it takes to get a limited divorce. And then you wait out the grounds, and then you come back in and get a final divorce. People often think that if they have a separation agreement and they get it signed, that that's the same thing as a legal separation, and it's not. Certainly, at least in Maryland, a legal separation is a limited divorce. It's when you have gone in and gotten the court to issue an order deciding on these particular things that you asked for in your pendente liste request. A separation agreement is just a contract between spouses that sets forth their agreements with respect to any of the issues involved in their case. So they may agree on who gets to live in the marital home. They may agree on custody. They may agree on child support. Those kinds of issues are spelled out in a document and signed. And they're very, very useful in family law cases because courts really prefer that people handle their business in private. They don't really want to decide a visitation schedule for the family. They would prefer that people were adults about it enough so that they could do these, make these agreements themselves. And the courts feel like if people do make agreements themselves, that they're more invested in making sure that they're abiding by the agreements. So some of the interpreting issues that might come up in this type of a matter is primarily site translation. You might have to do a site translation of a separation agreement. And of course, you'd want to do that with the attorney present to answer any questions. If the parties do have a separation agreement in place, it's much more likely that the amount of time needed from the interpreters in court is less. The case is more streamlined if parties have decided some or all of the issues themselves. And so the court will only be asked to decide on a limited number of matters, which means each side only has to prove a limited number of matters, and that cuts down the time that you will be interpreting. So you need to ask the attorney during preparation, do the parties have an agreement? Sometimes, and are there any issues that the court is going to be asked to resolve? Sometimes if they do have an agreement on all of the outstanding issues, then even though the docket says you're there for trial, really not. It's called a consent agreement, and they're just going to go in and put it on the record by reading it. And then the court's generally going to accept it as long as the issues with respect to the children, child support and custody, are fair and reasonable. So even though the court clerk says it's a trial, if I can find out whether there's a consent agreement and it's just going to be put on the record, then I can staff the case more efficiently by assigning only one interpreter to it, right? Because if they're just going to go in and read a 5-page document, you don't need to have 4 interpreters there, 2 proceedings interpreters and 2 table interpreters. So that's part of your obligation then, is to gather that information so you can intelligently and efficiently help the court ensure that there's language access, but at the same time not overstaff the case. And along those lines, if you know that there's going to be a consent or separation agreement read into the record, ask to see a copy of it and read it, because all of the issues that we're going to go through will have to be spelled out, and of course it's being read, so it's much quicker, and you'll want to take advantage of that piece of preparation. So then you'll know that if the court is being asked to resolve a number of issues the matter's going to be more complicated, and you may need a full team of interpreters. If the court is being asked, and we'll go through this a little bit later, but if they're being asked to resolve property issues, then you need to be prepared for complicated math concepts, things like actuarial issues involving insurance and life expectancy, property values now, property values in the future, because one of the parties might have the right to exclusive possession of the home for a period of time, and then the court might order it to be sold. Retirement assets and the like, all involve somewhat complicated mathematical concepts. If issues that you know will be litigated relate to custody of children, then the interpreter needs to find out whether the children are going to be testifying and if they use interpreters, and if they have attorneys, which we'll come back to. But this impacts staffing because of the need for deaf interpreters if you have children in a case. The kids may be testifying in open court, but depending upon their age, particularly for younger kids, they often meet privately with the judge in chambers, sometimes with counsel, sometimes without counsel, typically not with the parents, because the judge is trying to get an idea of their views on custody and where they want to live. So if the kids do have their own attorneys, then staffing of the case is also affected, because if they're deaf, if the kids are deaf, then they may, even if they're not deaf, the attorney may want to have a table interpreter present for themselves and their clients, obviously, if the kids are deaf. Okay, so that's the basic concept of a limited divorce. Now moving on to when your grounds ripen, then there are different matters that an interpreter might find themselves interpreting in a contested divorce case. So as I mentioned, if you're asking the court to resolve any of the issues that arise during the marriage, and an issue is something that you don't agree on, so it might be custody, child support, property, whatever, then it's called a contested case, and the party filing the complaint has to prove their case as to each issue that's contested. Knowing that will help you predict as an interpreter. Knowing if it's contested, finding out what the grounds are that we'll go through, will help you better able to more effectively interpret, because you'll be able to predict the content. So, and also because the parties want different things, and they want different resolutions on the outstanding issues, they might file counterclaims and cross-claims. So here we have a plaintiff or petitioner and a defendant or a respondent. The plaintiff might file a complaint, and then the respondent might file an answer but also include a counterclaim saying, no, give me the divorce, no, I want custody, that kind of thing. So whenever you're asking the court for something, you have to prove it, that you're entitled to it. Absolute divorce is just the term we use as compared to a limited divorce. The grounds have ripened, and the parties are asking the court to dissolve the marriage finally. Once that's done, in other words, once an absolute divorce has been granted, the court's no longer involved except with respect to child support and custody, because the court has jurisdiction then to hear any kind of issues that come up while the child is still a minor that relate to a material change in circumstances. So in our history, you typically had to have a legal reason to get a divorce, as I mentioned, grounds. You couldn't just get married and then get divorced. The state had an interest in ensuring that didn't happen. As times have changed, states have created what's called a no-fault divorce, and that's one in which neither the husband or the wife is officially blaming the other for a breakdown of the marriage. Your states might call them different things. Maryland calls them a 1-year voluntary separation and a 2-year involuntary separation. It's difficult to get a divorce in Maryland. In the District of Columbia, it's 6 months voluntary separation and 1 year involuntary separation. You might hear these grounds called irreconcilable differences, or an irretrievable breakdown of the marriage, or incompatibility. It just depends on how your state statute is written, and it essentially, again, means they agree, they want a divorce. They're not blaming each other. In Maryland, we have some fairly typical grounds. We have adultery. We have desertion, but only if the following 3 factors are met. The desertion has to have continued for 12 months without interruption before the filing of the divorce. The desertion is deliberate and final, and there's no reasonable expectation of reconciliation. Those are the elements that you have to prove. So when you're interpreting and you're predicting, those are the elements that you're going to see presented in the testimony. They're going to have to draw questions, use questions that draw answers that prove each of those elements of your ground desertion for getting a divorce. So understanding the grounds in your state is going to help you predict, as well as some of the other kinds of preparation information that you'll do, reading the complaint, talking to the attorneys, that kind of thing. Typically, states are also going to have some kind of ground that allows a divorce based on a conviction of a serious felony, on insanity. And again, Maryland has that, but we have a number of items that have to be proven. So we have to have 2 doctors come in, 2 psychiatrists come in and provide testimony. Again, knowing that, if you know what the grounds are, you can start to predict what the trial looks like that you'll be interpreting. And then recently, as with limited divorces, because domestic violence is such a problem in this country, Maryland added 2 different grounds, as I already said: cruelty of treatment and excessively vicious conduct. So if none of these exist, then the party doesn't have standing. You're not qualified to get a divorce. And if they need the court's help because they've separated, then they need to file for a limited divorce. A couple of miscellaneous issues just to keep in mind, and this depends upon the state as well, but alimony is used to be provided when one of the parties was unable to work after a divorce for whatever reason, typically because the person was a homemaker and they had spent their career supporting the spouse that worked. Then at the time of divorce, they could ask for a monthly payment to help them maintain the standard of living that they enjoyed while they were married. Today, indefinite alimony is very limited, at least in Maryland and the District of Columbia. What they do have is called rehabilitative alimony, or fixed-term alimony, because it was felt that indefinite alimony was sort of like a lifetime pension, and they preferred that people were able to, when appropriate, become fully self-supporting. So the purpose of that kind of alimony today is to provide funds so that the person who's receiving it can get the training and education and become financially self-reliant. There is still, however, indefinite alimony, but it's difficult to prove. You have to essentially prove that the person will never become able to make substantial progress and become self-supporting, or that the respective standards of living between the parties would be unconscionable. You're going to hear that phrase, standard of living, over and over and over in family law. And it's a concept that's common, and it requires the interpretation to be explicit and comparative in terms of what the party's life was like before, during the marriage, and what their financial situation is like and their level of comfort is like afterwards, because it's a concept not only with alimony, but we'll see it again with child support. So it requires thought and separation to interpret. An annulment is, and most people are a little bit surprised to learn this, but you can't just get an annulment because you were married for 24 hours. An annulment is the legal ending of an invalid marriage. So according to the law, the people were never married. And the grounds for an annulment vary by state. But like I said, it's not, oops, we made a mistake with this marriage. It's usually stuff like one of the parties was already married, so the second marriage was invalid by law. Those are, or that it was somehow entered into with severe or provable fraud. You might hear the term common law marriage, and that's a relationship between a man and a woman that some states do recognize as being legally married, even though there was no license ever obtained and there was no marriage ceremony ever held. If, in fact, you're in a common law marriage, then a divorce is required to terminate the common law marriage. You have to do a number of things like hold yourself out to the world as married, wear rings, share finances, that kind of thing. You might find yourself in a number of different matters that deal with paternity. And paternity is simply determining who the actual father is, and it's usually in relation to a complaint for child support. And also, an unwed father can come forward voluntarily and claim paternity and file his own motion for paternity, and then you have to have some kind of either a blood test or a DNA test, and it can be litigated. You may have heard of prenuptial agreements, and for many, many years they were not permitted. It was felt that they were against public policy. It was bad policy to encourage people to write a contract about how they were going to divide their property when they got divorced. So they are now permitted. It depends on your state, of course. But they usually set forth alimony and property rights. They have to be in writing. They cannot be oral. And the litigation that you see is when one party or the other says that they were induced by fraud or mistake or duress to enter into the agreement, and that it should be invalidated. So in terms of this slide and the interpreting implications, you might find yourself going with alleged father to have a DNA test or swab, or you might do a site translation of a prenuptial agreement. More likely you'd be interpreting the case fighting over whether that agreement was valid or not. And interestingly, the common law marriage sometimes comes up as in a criminal matter. So if you're married, there are privileges. The marital communications privilege you can't be forced, your spouse can't be forced to testify to communications made during the lawful marriage. And that actually came up as a defense in the Gallaudet murder trial that was Joseph Mesa's trial, gosh, 10, 11, 12 years ago now. He had made some statements to his girlfriend. And so his argument was that she wasn't really his girlfriend, she was his wife, and the District of Columbia recognizes common law marriage. So the state couldn't force her to repeat any of the statements in court that he had made to her at or shortly after the time of the murders. He lost, but like I said, you might see it even coming up in criminal law matters. All right, so we're going to take a break here, and I'm going to look at, you can go ahead and type your questions in if you have any questions with respect to what we've talked about thus far. Oh, goodness. Hang on. Okay, well, I'm looking at Catherine, I don't know that I know how to pronounce your last name, Taber's question. You mentioned conflicts. My local court has a mediation option where the parties can meet with a court employee who's a mediator, usually an MST. The mediators meet individually with the parties and children and with the parties together and write an agreement which is then brought into court for the judge to affirm. Would conflicts exist in this situation, which would require separate interpreters for each party? Same question for pro se parties seeking help from the self-help clinic. One party might show up on one day, and the opposing party could show up on another day. So I actually address this particular point a little bit later when I talk about ADR and the interpreting implications. So and in addition, I don't know what an MFT is, but I suspect it's a California thing, either that or it's a degree. But so I will address this a little bit later. And Glendia Boone is asking, is disillusionment still on the books as a divorce option? Disillusionment has never been on the books in Maryland that I'm aware of as a divorce option. So in your state, you'd have to check your state court website to see what your list of grounds are. Deb Martinez, will you be talking about staffing a contested divorce case and separation of teens during the trial phase in a contested divorce case? Yes, except that I'm not entirely sure I know what you mean by separation of teams. If you mean keeping separate the table interpreters who are working privately for the parties from the proceedings interpreters who are working for the court, yes. If you mean something else, I need some clarification. Okay, Patricia Hauser, please explain the word standing. Sure. Standing means whether you're qualified to file a divorce case, or any lawsuit for that matter. Every lawsuit says you have to have standing. So in Maryland, you have to, one of the parties has to have lived in the state for a year prior to filing the complaint. You have to have grounds, so you have to have that legal reason. It might be adultery, it might be 2-year separation, 1-year voluntary separation. So each state is going to have a list of qualifications that says who can get divorced and who cannot. And if you qualify by satisfying each of those elements, then you have standing. Krista, did the common law defense stand if she was his girlfriend? I assume that you mean Mr. Mesa, and no. And it wouldn't stand if you held yourself out as girlfriend and boyfriend anyway. It only stands if you hold yourself out as being married, even though you haven't gone through a ceremony. Thank you, Catherine. Marriage and family therapist. More and more courts are requiring ADR and mediation, and yes, the goal obviously is to come to an agreement, and I'll go into the interpreting issues a little bit later. Here's a question from Suzanne Terrio regarding a conflict or perceived conflict of interest. If we interpret for a client in family law court, and then the client is later brought up in criminal charges for the breach of terms and conditions of the divorce decree, we are called to interpret the criminal case. Well, that doesn't happen in the states that I'm licensed in. There's no criminal charges brought for a breach of contract. Essentially, a separation agreement is a contract. If there is a violation of a court order, because in the divorce, you'll probably hear this, but in the divorce they merge and incorporate the settlement agreement into the decree of divorce. Because if they don't, then in order to enforce it, they have to go to regular civil court, just as you would any breach of contract. But once it's merged and incorporated into the divorce decree, then the court can enforce it through a contempt action. If I'm the proceedings interpreter for the initial divorce decree, and I'm the proceedings interpreter for the contempt case, then technically there's not a conflict of interest. There may be a perceived conflict of interest, but that's more subjective in terms of whether or not the interpreter feels like the deaf person's going to trust them, that they're interpreting well the second time around. And I suspect that's less of a concern because they're probably more concerned about not going to jail on criminal contempt. But I don't know, so it's possible. Carla Goldsmith, yes, standing is jurisdiction. Standing is broader than jurisdiction. Jurisdiction means, does the court have either the subject matter authority to hear the case, or does it have the actual person in front of them so that they can hear the case? That's how we typically use the term jurisdiction. Standing is broader because you have to not only have subject matter and personal jurisdiction over the person, you also have to meet the elements of what you're asking the court to do, and you have to meet and prove those elements. So if you don't have if you don't have a 1-year separation, you can't get a voluntary divorce in Maryland because you don't have standing, although the court has jurisdiction because you're in front of it and they have the subject matter authority to hear the case. But it's a great point, and that's one of the things that you all need to do is to research the terminology used in your state and how it may vary or differ. So I'm going to continue on, and I know there are other questions there, but I want to make sure that we have time to get through everything. So if there is time at the end, I'll come back where we left off with Dave Morrison's question. Right. So another major issue is marital property. We've touched on it before. We've touched on the separation agreement, which is also called a property settlement agreement. So if you're married and you're getting a divorce and you have no kids, and you're just dividing up the property, then this is what it would be called. And the courts are of the opinion that people can pretty much divide their property as they see fit. And they just write it down in a contract, a property settlement agreement. And that's how both property and debts are resolved. And although many divorces start with a high degree of acrimony, by and large, most of them settle. And when they can get to a settlement, then you put it down in a property settlement agreement. And if you can't agree on what to do with your property, then the court's going to decide for you. And the laws are going to vary from state to state as to how do they do that. But most states they have a difference between marital and non-marital property. And if you can establish that a piece of property is non-marital, then you get to keep that. You don't have to split it. So courts, at least in Maryland, are more concerned now not with how a piece of property is titled and whose name it's in, but rather how and when it was acquired. So if it was acquired during the marriage, then it's marital property and it will be subject to division. If it was either from an inheritance, a gift, or there was a valid prenuptial agreement, then it's non-marital property. So again, every state's going to be different. Out west, as you know, if you live out there, those states came into the United States the last. I mean, they're newer states, than Maryland, and many of them are what we call community property states. And that essentially is that if property was acquired during the marriage, then it gets split down the middle, unless there's a valid prenuptial agreement. So most of the other states are what we call equitable distribution states. Because the court can't take a title to a house, and if it's in the husband's name only, they can't force him to change title. At least in Maryland, our courts don't have the jurisdiction or the authority to do that. But what they can do is they can take an inventory of all of the property that was acquired during the marriage, look at how it is titled, and then do an offset. And that offset is essentially based on what the court thinks is fair. They also look at things like fault in the demise of the marriage, need, length of the marriage, contributions to the acquisition of the property, and then they divide it. It's called equitable distribution. So essentially, if the husband has a house and it's worth in his name, and it's worth $300,000 in equity, the court can't order the court cannot order title changed to make it a jointly owned house, but they can order the husband to pay wife $150,000. That would be how they would equitably distribute the property. But first they have to figure out what is marital property and what's non-marital. Then they do an inventory. Then they listen to testimony on the various factors that are set forth in the statute about why the marriage is being dissolved. And then they make a decision. You'll hear lots of talk about pensions. Because a pension is your property, but you don't have a right to it until you retire or until you reach a specific age. And if you were divorced years ago, then your spouse may have a right to a percentage of that, at least a percentage of that pension that was earned during the marriage. So you will hear the word, it's an acronym for Qualified Domestic Relations Order. You'll heard that pronounced quadro, Q-D-R-O. And that's what it's dealing with, is how to divide a pension that portions of the pension were earned while the parties were married. So you'll hear other terminology about the amount of non-marital property each spouse has. You hear about what their earning power is, whether they provided or contributed to the marriage the services as a homemaker. You'll hear two words. One is waste and the other is dissipation. And those typically mean that one person in the marriage had power over the property and they wasted it. And the purpose of wasting it or dissipating that property was to avoid having to share it with the other side. So in terms of interpreting, other than criminal and minor traffic cases, court interpreters find themselves in family law matters most often, and they're high stakes and they can be complicated. And unless you've gone through a divorce yourself, the concepts can be foreign. So it takes a lot of preparation. And I know one of the things interpreters tell me is, well, I don't really need to know all that, because isn't it the lawyer's obligation to explain all that prior to their client, during preparation? And that is true. It is the lawyer's obligation. I don't think it lessens the interpreter's obligation or responsibility, at least, to be familiar with the most common concepts and to be familiar with how their jurisdiction talks about the concepts. You know, and in addition, not all attorneys spend a great deal of time with deaf clients, and you don't know who's interpreting. You don't know if it's a family member that they brought with them, or if the attorney actually hired a professional interpreter, or if they, you know, did all of the preparation on VRS. So we don't always know. But I think, for the most part, those are the basic major issues that you're going to see in marital property. Questions? Quadro and Amy Hermanson. Oh, June Prusick actually answered Amy's question. Yes, qualified domestic relations order. Okay. Mr. Rothenberger is asking the interpreter to move a bit to the left. I'm sorry, to move to the center from her left. Okay, well, that's all right. We don't have questions about property. There's a lot to get through still. And so we'll move on. Custody. If the parents can't agree on the custody of their child, then courts were going to decide custody based upon what they call the best interest of the child standard. And determining where it's best for the child to live is no easy matter. And there's no one or two or three factors that the court looks at. It's usually a lot of different factors. And the factors are important because knowing them, you can anticipate what the deaf people are going to testify to. Because whoever's asking for custody has to prove these things. These are some of the factors. That which parent is the most suitable custodian based on their character, temperament, and stability. They have to testify as to the child's relationship with each parent. The court will look at the educational level of each parent, their child-rearing skills, whether they have an illness that might harm the child, which parent can provide a better home environment, whether the child has stronger ties to one or attachment to one or the other parent, where the child's been living on a regular basis. That we call the status quo, and courts don't like to disrupt the status quo when it comes to where a child lives, because they'd much rather disrupt the parents. And we have a concept called nesting, I think that's what it's called, where essentially you have to have three homes because they leave the child in the family home, and when mom has custody, she moves in, and then for a month or so, and then she moves out and dad moves in, and they go back and forth that way because the court doesn't want to disrupt the status quo where the child's been living. So they also look at relatives and if there's extended family that can help. They look at employment status, financial status. Sometimes they look at the motive the parent has in seeking custody. When you have custody, you also get paid child support to take care of the child. So sometimes that's a motive for seeking custody. We look at whether one parent is unfit or fit. And importantly, and particularly in recent years, is which parent is most likely to allow the child to continue in his or her relationship with the other party, other parent, or extended family. Courts want to see parents who are divorced get along and communicate. And when they can't get along and communicate, then they get punished, essentially by not being given things like joint custody, which I'll get to in a minute. And it used to be that there was this maternal preference in custody. So they called it the tender years presumption. And for almost 100 years, there was a presumption that the mother would be a better custodian for the child. That's historical in my view. I don't think any place in the country uses that presumption anymore. It would probably be unlawful to use it. All right, so again, knowing the best interest standards, knowing what people are fighting about will help you predict and anticipate death witness testimony. Guardian ad litem. Sometimes they're just called GALs. Sometimes they're called court-appointed special advocates, or CASAs. It just depends on your state. But when in a contested custody case, it's their duty to advise the court, among other things, on what is in the best interest of the child. So courts often appoint a GAL to represent a minor child, and they have different roles depending upon what the court says. So they might be there as an advocate for the best interest. They might be there to investigate, to try to find out what is in the best interest. And they might function as a guardian, where they can actually make decisions for the child. So an attorney can present a child's perspective to the court, can seek an evaluation if it's necessary, like a professional psychological evaluation or whatever the GAL thinks is necessary, and can seek the testimony of the child's doctor about what's the best thing for the child in terms of their development, and can also do things like do home visits, school visits, and custody evaluations. Sometimes the child is too young to personally exercise a privilege of confidentiality that the child might have with a psychiatrist or a doctor. And it's presumed that the custodial parent has a conflict of interest in trying to make that, waive that privilege. So they appoint the GAL, and essentially what they're doing is they look at the whole situation and determine whether it's in the best interest of the child to waive this privilege or not, to say, let their doctor or let their therapist testify. Okay, so that's guardian ad litem. They're called different things, and if the children are deaf, then that has implications for providing table interpreters for those attorneys. Both during the matter while it's in court and for preparation. Legal custody. Legal custody essentially is a decision-making power. It has nothing to do with where the child lives. It's the right and obligation to make long-range decisions involving the child's education, religious training, discipline, medical care, and other important matters in the life and welfare of the child. Again, it doesn't relate at all to where the child lives. Joint legal custody means that both parents have an equal voice in those long-term decisions, and neither parent has a superior right to make those decisions. It's absolutely critical that parents are able to communicate and to cooperate with each other, and if not, at least in Maryland, you will not get joint legal custody. So, physical is also called residential custody. That deals with where the child lives and for what portion of the time. It's the right and the obligation to provide a home for the child and to make those day-to-day decisions that are required when the child is actually with that parent. So there's the custodial parent, who the child might live with most of the time, and when the child's in their custody, that parent makes the decision. The other parent has visitation rights. But when the child is with that parent who has visitation rights, they're in the custody of that parent, and that parent makes the decisions as to the day-to-day decisions. So that's physical custody. Joint physical custody, at least in Maryland, doesn't exist, but we do have shared physical custody. And you just look at how much time the child spends with either the mom or the dad, and you come up with a percentage of how much time. That percentage is used then in calculating child support, because we have different, and we'll go into child support, but we have different percentages that apply depending on how much time you actually have the child in your custody. Joint physical custody helps tremendously if the parents live close. If they live far away, then it's difficult because of school and travel to get any kind of joint physical custody. Okay. So along with custody always comes the issues of child support. Federal Child support is money paid by the non-custodial parent to the parent who has custody. It's not taxable to the parent who gets the support, and it's not deductible for the person paying for it. All 50 states have what we call child support guidelines, and they're essentially a table that indicates the amount of support based on income and certain expenses like child care and health insurance. Again, usually the parent without custody pays child support. But it can also be reduced if the child spends more time with the non-custodial parent. Congress has gotten involved and has a number of different enforcement mechanisms in order to ensure that child support is paid, because it has an interest in making sure that, I think it's called TANF now, but it's Temporary Aid to Children and Families in Need. It used to be called AFDC or welfare. Congress has an interest in ensuring that people pay their child support obligations so that the state isn't doing it. So they allow now seizure of bank accounts, suspension of driver's licenses and professional licenses, and investment accounts in order to levy upon those and to make those child support payments from what's been called the deadbeat parent. So a couple of concepts that you'll hear in any child support litigation. One is voluntary impoverishment, and it's when a person can work, but they choose for their own reasons not to work. So they have voluntarily become poor. And if that's an argument or if that's an issue in trial, then there's got to be proof that the person could work, and you have to have some kind of evidence as to what they would earn if they were working. And if the court finds that they in fact are voluntarily impoverished, then the court will do what it's called impute income. So imputing income is a concept you'll hear over and over, and it just essentially means you make $10 an hour, but we find that you could make $50. So we're going to say that you make $50, and we're going to base our child support decision upon the amount that you could work or you could make if you weren't voluntarily impoverishing yourself. So child support and custody, like I told you, courts have continuing jurisdiction to hear those cases, and they come back, and they come back, and they come back, because people always want to have a modification hearing. And at least in Maryland, there has to have been a significant or material change in circumstance in order to have standing to file a modification. for the court to hear a modification. So that's usually the first fight is, are things the same or have they changed? And how have they changed? Maybe someone lost their job. Maybe one of the parents moved out of the country. Those are the kinds of instances that rise to this material change in circumstance in order to ask that child support and custody be modified. Right, so interpreting implications, math, I already said that. Math, and some of us are just good at it and some aren't. And while the guidelines are actually run by a computer, you'll still hear things, you'll hear the word and you'll hear things like his income is outside the guidelines or it's within the guidelines. So there needs to be, you don't need to know how to do the guidelines, but you need to be familiar with what they are in your state. Also, as I mentioned, imputing income and voluntary impoverishment are common in family law settings. So we can predict and be able to handle it because we have predicted an appropriate interpretation of them. Okay, quickly, questions. Chris Dylan says marital, oh, this is our property question. Marital property is divided, but items from before the marriage are kept by the individual. Yes, if they're entirely brought into the marriage and not added to, the value's not added to during the marriage. So if my mortgage, I have it before the marriage, then I go into the marriage and pay my mortgage with money earned during the marriage, then that becomes partial marital property. Jody Wiedemann is mentioning that a gal is an attorney. Here they call it a guardian. A law guardian. Yes, in Maryland, gals are attorneys. And in New Jersey, gals are not attorneys. So there you have it. There you have to look at your own state because there are 50 state statutes governing all of this. I'm going to try to get down to child support questions. Dave asked me about the new Defensive Marriage Act being held unconstitutionally, one section of it. I can't really answer that question. I do know that one of the things that they didn't touch was the full faith and credit provision of it. So it's unclear at this point whether a marriage in one state must be recognized by the other state. But you know that that's all going to get worked out really quickly. Okay, Maria, you asked about when figuring out how much is to be paid if someone has been determined to be voluntarily impoverished, how is that money paid or collected? And I just went through those enforcement mechanisms. So your tax refund, if you don't have any assets because you quit your job and you didn't want to pay child support, quit your job is not a good example because then you wouldn't have a tax refund. But your tax refund can be garnished. Your wages can be garnished. It's the same way that anytime you win a case, then you have to go figure out how to collect your money. So it's just that with child support, the state's going to help you. Whether if you were trying to collect a private debt from a lawsuit, the state isn't going to help you so much. And Anna said, I was trained and worked as a GAL in North Carolina for several years. You're not required to be an attorney, but you are required to be college educated. Okay. Okay. We're going to move on. Just briefly about visitation. It's still the best interest standard. And I've already said that the person who doesn't have custody has visitation rights, and the person and also pays child support to the custodial parent. There's, again, courts prefer that you work out your own visitation schedule, but if not, there's just essentially a default that they go to. So it's like every other weekend with the non-custodial parent, every Father's Day with the father, Mother's Day with the mother. You alternate birthdays, you alternate holidays. You may or may not have a day during the week. So, but of course, that's only what the court's going to do. I mean, if people agree to something more and it's in the best interest of the child, then courts are going to permit it. Visitation isn't an absolute right. It can be suspended, denied, or restricted if the court finds that it's not in the best interest of the child to have visitation. But at the same time, that's balanced between the court and the state not interfering with family relations. So even if you are incarcerated, that's not an absolute bar to visitation. And in fact, one of the places that we see sign language interpreters often is at these supervised visitations that occur in our courthouse on the weekends. And so generally, a parent's right to visit with their child is not going to be denied, but if there has been violence, if there has been some other circumstance that endangers the child's physical, mental, or moral, or emotional health, then a court could certainly limit visitation and sometimes outright deny it. Third-party visitation is depends on your state statute, but if there's a divorce or if a parent dies, you can frequently see a grandparent petitioning the court for visitation rights. So that's third-party visitation, someone who's not the immediate family but has an interest in the case. In terms of interpreting implications, I have to say that fighting over children and visiting schedules has been some of the hardest legal work and interpreting work that I have ever experienced. It's emotional, it's draining, it's way too easy for an interpreter to sympathize or develop a prejudice, either for or against one side or the other. And so we have to be very, very careful about keeping those feelings in check. And as a court interpreter, as a table interpreter, there's a little bit more leeway because you're part of the litigation team. It's, again, another reason why we want to keep those lines of separation absolutely clear in our roles. What I mean is if you've done the table work in this kind of a contested case, you don't want to do the proceedings work because it's just too easy to become biased. I've seen a judge grant custody to a hearing spouse over the death spouse because the judge felt that the death spouse who wore a hearing aid and took it off at night would not be able to adequately supervise a teenage boy because she didn't wear her hearing aid overnight. Obviously using the fact that this person is deaf against her in making a decision about granting visitation, granting custody. Devastating. So these custody and visitation contested trials require full staffing. You really don't want to be sharing interpreters because not only can it be perceived as a conflict, but emotionally it really can be very difficult to keep separate. Okay, I'm going to run through this quickly. I thought this would be a lot shorter than it's turning out to be. Contested cases, I just want to go through the procedure briefly. There's and the interpreting implications of each. And the initial interview is a really important time for an attorney to develop a rapport with their client. So if that's what you're interpreting, you're the table interpreter, and just know that it's a really critical time because the attorney's evaluating the client's evaluating the attorney, trying to figure out if there can be a rapport, and you've got to get information about the case. So you've got to find out what the contested issues are. You start filling out forms, the joint statement of marital property, income statements, monthly needs, other financial statements, so there may be site translation. Then you commence the suit. And how a family law case proceeds is a party makes an appearance, and we call it an action. And I only point it out because in court and in legal settings, we use English differently than we use in other settings. So in hearing that as an interpreter, you might think that the attorney who has to enter their appearance actually goes to court and appears in the case. But it's not how it happens. We file a paper entering our appearance, and that's essentially a formal way of telling the court, I'm the attorney in the case, and then the court stops communicating with the client and communicates only with the attorney. So then there's a complaint filed, and you set forth in the complaint what it is you want the court's help with in dissolving the marriage. And you also have to set forth the facts to show the court has the power to hear the case and that the parties are fully qualified or have standing to make the request that they're making. All right? The complaint has more content than an answer. So you file a complaint and then the respondent files an answer, essentially addressing each of the paragraphs in the complaint and either admitting or denying them or saying I don't have enough information to admit or deny. So if you're an interpreter and you have limited time, you've got the case file, you want to read the complaint as opposed to the answer. Ideally, you'd like to read them both. If the defendant doesn't answer, then it's an automatic win for the plaintiff, and we call that a default judgment. Then there's a period of discovery. Discovery, as in any civil case, has interrogatories, depositions, requests for documents. You go through that. Interpreter's role is important there. Then in ADR, ADR is called alternative dispute resolution. There's a lot of different types. They are used both before litigation and contemporaneous to litigation. So you may always have settlement talks going on while the case is being litigated. Most courts have a scheduling system so that when you file a complaint, you put on a schedule, and ADR is part of that. And that means you show up. Also, you show up, there's a mediator there, and typically the mediator has some kind of confidential settlement statement that's been provided ahead of time that they can read so that they can come up to speed on the issues. They listen to both sides and they split the parties. And the mediator may jump from plaintiffs to defend, or plaintiffs to respondents and back. What I as an interpreter do during that is typically stay with the mediator, unless there's not a table interpreter present. And then if everyone agrees or stipulates, then I'll stay, knowing that I'm going to be doing privileged communications and then interpreting for the mediator. Interpreting for the mediator is not court interpreting. There is no oath. There is no record. There's an express agreement that the mediator will not be called and that nothing that happens during that mediation can be used as evidence. Right? So there's less of a risk of me working from privileged communications to public than if I were working privileged communications to a court hearing, because it's ADR and it's mediation. And plus, if I refuse to stay in the room with the attorney and the client, that means they're not going to be able to rationally or easily discuss the merits of any offer to resolve the case. So I'm not assisting the court in its efficient administration of justice. In fact, I'm impairing it if I refuse. Now, it may be that if I agree to do it, something might happen during the day that would preclude me from taking further work. But for that day, generally, Carla, as the interpreter, I'm going to be doing both of those items if they haven't brought their own table interpreter. Right, and the last point I had about that was that as the interpreter, it's sort of my obligation to acquire enough facts ahead of time to adequately help them staff that case. So if I know it's going to be a day-long settlement, then I know I need a team interpreter. I can find out from the attorney how they plan on communicating privileged communications. Part of that is my obligation to do. So that was in part in response to Catherine's question about jumping sides and conflicts, etc. And then there's merits hearings, which are trials or any evidentiary hearing where a case has to be made, and then you may take an appeal from the decision of the court. In Maryland, we call them exceptions from the decisions of, we have masters. Masters are judicial officers who hear cases that are less complicated than full trials. And when we disagree with them, we take exceptions. All right. So we're going to do this on August 19th, and I'll just save this slide for them because that's our next webinar, and it's all related to domestic violence. In terms of just some final thoughts, because I see that I'm running out of time, we have some related matters. The family law system and you interpreting in it will run across cases in the child abuse and neglect system. There's this concept called parents, and it's difficult for me to pronounce, but I think it's patriae. It's Latin. Nobody knows how to pronounce Latin. And essentially what it says is that the court has an interest in ensuring that children are raised right or properly. And if parents can't take care of their children, then this is what gives the state the right to intervene in the family for the sake of the children. It's the basis of this abuse and neglect system. Abuse and neglect cases, again, are all going to be depending on your specific statute, but we have them called CINA, C-I-N-A, which is Child in Need of Assistance. And in Virginia, another place I interpret, we have CHINS, C-H-I-N-S, which is Child in Need of Services. And those essentially are when the state says the parents aren't taking care of the children and we're going to get involved. So sometimes they get involved and take away custody of the children and give it to a third party. Sometimes if the parents cannot be rehabilitated in a proper manner, in a proper amount of time, then that third party custody morphs into a termination of one's parental rights. In Maryland, we call that guardianship with consent to adopt. Just depends on your state. But a termination of parental rights is a very serious matter. And it can be devastating to the parents. And frankly, interpreting a termination can be extremely traumatic for the interpreter as well. I interpreted a case many years ago where this young woman, it just shows the trauma facing deaf people and interpreters, but she became pregnant every year. And 2 of her children had died while they were in her and her boyfriend's care. And all of the other children were removed to other family members. So she was prosecuted in a criminal matter for negligent homicide, as was her boyfriend. In that case, I worked for her boyfriend and his attorney. And we went to his home to do a home study, and he lived with this very elderly man. And it came to light that he thought this man was his father. He never realized that this man actually was his grandfather. And his girlfriend had gone to a doctor and wanted to be sterilized because she kept getting pregnant. I don't know that she ever understood the relationship between sex and pregnancy. And I don't remember now, but either the court or the doctor refused to sterilize her. So my whole point of bringing up this story is that you need to be healthy to interpret in these matters, because you're going to be faced with a lot of really traumatic things for deaf people. And if you're also being traumatized, then that's not a healthy interpreting situation. And I'm sure that there are many, many other stories that folks could tell. So a final word about juvenile court matters. Juvenile court is a branch of family court, and there's two kinds of different tracks that a matter can take. It might be a delinquency proceeding where the state has charged the juvenile with violating a criminal statute. Those are sometimes, but not always, heard in juvenile court. And the goal of the disposition is to rehabilitate the offender. Some states even have special sentencing provisions so that their records are protected when they become an adult. There's another type of matter called a status offense, and status offenses are imposed upon young people, but not on adults. So they're based on a characteristic related to age. So, like a curfew offense, an adult wouldn't be arrested for breaking curfew, whereas a child can, or truancy from school, or what they call being incorrigible, or running away from home. Those are all status offenses that are going to be heard in juvenile court matters. With that, I want to note that the next webinar is going to be August 19th. And I did it again. I believe that this time is wrong. We'll get the correct time out. And it will be interpreting in domestic violence matters. Again, there's a change in the final date. It's not September 7th, it's the 21st, and this is the correct time at 1 o'clock. And there are your archive sessions and CEUs. I will turn it over to Carla now, Carrie White, so that she can explain that procedure to you. And thank you, and good night.
Thank you, Carla. Just a few things, and please don't get off till I finish so you can get all of your CEU information. I especially want to thank Carla Mathers for presenting all of these webinars. I'd also like to thank Kirk and Terry, our interpreters, and Carol, our captionist. And many thanks to our clearinghouse team, Jessie and her staff. They are just amazing. Okay, the reminders for the CEUs. After you close out of this webinar, a survey will come up, and you fill that out on how much you enjoyed the webinar tonight, and it will also collect your CEU information. That is for individuals. If you have a computer, you are logged in, please fill it out. There is a sign-in sheet for groups only. If there's more than one person watching the webinar and they only have the one computer, they may send me the filled out sign-in sheet form. The listserv is ongoing. I will send out an email in the next couple days, and it gives you an opportunity to ask Carla more questions and to interact with your peers. Please look for that as I'll send it out. And thank you very much, and have a great evening.
Thank you, Carrie.